Thank you all for being here, if you're here in person, or especially those that are watching this recording of this webinar. We are very happy you joined us today for a webinar hosted by the Master of Legal Studies in Cybersecurity and Data Privacy at Cleveland State University's Cleveland Marshall College of Law. Today, we will discuss data privacy in a post-Roe America, and specifically examine the question, in states where abortions are illegal, can women seeking abortions be tracked digitally and therefore prosecuted? I'm very grateful to have with me today two faculty members from Cleveland Marshall College of Law that I work very closely with, so I'm very excited to hear from them. Firstly, I'd like to introduce Professor Brian Ray. Brian Ray co-directs and founded our Center for Cybersecurity and Privacy Protection. He teaches in our JD program, as well as this Master of Legal Studies in Cybersecurity and Data Privacy. I know I always embarrass him when I say this, but I get so many good reviews from him, from the students. They truly enjoy his class in the cybersecurity program. So you will be so lucky to have him if you do this program. And then we also have Dr. Laura Hoffman with us, who also teaches in our JD program and co-directs the Center for Health Law and Policy. And I can also say that many of the students that I work with have Laura and think that she is just such a wonderful teacher. She takes so much time with them and is so knowledgeable in this space. So you are all in very good hands, either at our law school, if you have them as professors, or here in this webinar. So Brian, I'm going to hand it off to you to do some more introductions of both of you, and of course, start the presentation, and I'll come back later.
Thanks, Julie, and welcome, Laura.
Oh, thank you. Welcome, Brian, to you too.
Yeah, this should be fun. We, as Julie mentioned, both of us teach in the JD program, and I direct our center, and also created this program that many of you who are tuning in are interested in potentially joining. And so what we like to do on these monthly webinars is have a little bit of a substantive discussion with experts, both connected to the program and connected to the law school more broadly. And of course, front and center in the news, especially as we get really, really close to the midterm elections, is abortion. And one of the aspects of abortion that it's not necessarily overlooked. It's been in the news quite a bit, but it is not sort of core to the central question, but is a really, really important aspect of it, and illustrates how decisions by the Supreme Court in some substantive areas can often have fall-on effects, and also almost always intersect in some way or another with issues around data. And so that's what we're going to jump into today. And what I'm going to do is I'm going to stop sharing the slides so you can see Laura and I a little bit better, and we'll get back to those. And after we chat for a little bit, we'll bring Julie back on, and we'll tell you a little bit about the program, how to apply, and what our deadlines are. But let's jump in now and talk about our topic for today, Laura. To set the stage, what was the Supreme Court's decision? It's called the Dobbs decision for shorthand. That's after one of the parties. That's how we refer as lawyers to cases. We pick one of the parties, and there's certain conventions around it. But this case is known as the Dobbs case. And so, what happened in that case? What did the Supreme Court decide in effect?
I mean, in a nutshell, Brian, the basic idea that we get from this is that the seminal decision of Roe versus Wade, which injected a constitutional right for us, for women, to abortion, was overturned, returning that back to the states, which has really led to this hodgepodge of different, abortion regulations. Some of them being extremely lenient, and some of them being much more restrictive depending on the state. So that is it in a nutshell. I mean, it's a complicated decision. We could get into a lot more than that, but and I think since we are in the privacy area, I mean, it's important to say that it's not that the decision really specifically dealt with privacy or data, but that it's an after effect of this, right? And this returning all of this to the states, and that, you know, now we are in this really uncertain area for everyone as far as what that means, especially for medical professionals who are in the very difficult position of like having to figure out what their state criminalizes now, where the lines are drawn as far as when they can perform an abortion, and having to, you know, deal with these situations.
Yeah, so thanks for that summary. And just to reiterate, so the one of the key things to understand here is, as you said, the Supreme Court didn't actually say anything about abortion per se, except that by overturning Roe versus Wade, they're saying that the federal Constitution, and there's some interesting activity in the states, including state of Ohio, about whether state constitutions might nonetheless have protections. The federal Constitution does not have anything to say about laws regarding abortion at the state or federal level. And so from a kind of democratic perspective, that sounds like a good thing. It's basically saying, well, the court will not get involved in questioning, because there is no constitutional basis to question the legality or illegality of abortion at the state level. Now, that does have, in very broad terms, some potential effect on whether and to what extent there is a constitutional right to privacy as a matter of sort of, you know, in the civil context. We generally think of our Constitution as protecting privacy through the Fourth Amendment in the criminal context, but we also thought, and there was this sort of general sense that the 14th Amendment maybe had, you know, to use the old term, penumbra, that incorporated some sense of privacy, and the abortion decision were grounded to some extent in that. So there's a little bit of a, and maybe more than a little bit of a sense in which the scope of rights potentially protected, including other rights we might think of as in the privacy realm, might be in question now. But that's for another day. We want to focus on, as you said, the direct effect on data privacy and health privacy in particular. So
Absolutely,
we've already sort of set that stage and flesh it out. But just to get real concrete, so now we're talking about not the Supreme Court's decision directly and its effect on privacy, but what it opens up at the state level and how the potential changes in state laws create really potentially critical issues around data privacy in general and health privacy in particular. Could you map that out for us?
Yeah, I mean, I'll just start with, I mean, the idea that we do have a federal privacy law specifically for health related information. You've probably heard a lot about it. The acronym is HIPAA. We heard it a lot during the pandemic, and unfortunately, it was kind of like nails on the chalkboard for someone like me who teaches health law, because, you know, people are spouting out, oh, you can't get that information because it's HIPAA. Well, you have to really understand HIPAA and what it means, because it only applies to what are called covered entities, that are specific groups that are like healthcare plans, which are, you know, we're talking about insurance there, and we're talking about healthcare providers. And there's a couple other groups, but they are very distinct, specific groups that, you know, have these requirements under HIPAA as far as protecting what is known as protected health information. And the basic way to think about that is information generally in your medical health record. But as we are finding out that now that, you know, we are in this area of uncertainty and different states having different regulations as far as abortion and when it be, you know, when it is legally permissible, this creates issues as far as when, for example, law enforcement may seek information that could involve HIPAA. The reality is that HIPAA does provide exceptions for law enforcement. It also provides exception for something that is, you know, basically a part of the law that would allow a disclosure of what would be otherwise protected, medical information, which could be something like testing or, what was I just thinking? Testing, conversations with medical professionals is a big part of this, whether it's a nurse, a doctor, any of those. And the other part of this,
and actually, Laura, let me stop you there just to take a step back.
Yeah.
And before we get too deep into the details,
Yeah.
make sure folks are clear on. So the Supreme Court decision says states go ahead and do whatever you like with respect to abortion. There will no longer be the restrictions on what, when and how you can make abortion illegal. So that's the critical fact. And some states have said we're going to make abortion legal or are going to try to, but the concern arises out of states like Ohio and many others that either have passed a new law restricting abortions or had laws on the books that were never through the legislature changed, but that went quiescent, went unenforceable as a result of Roe and the cases that followed Roe. And so now, either whether it's a new law or an existing law that's come into force, those laws often, not always, but often contain criminal penalties for seeking an abortion. So it is, it's subject to enforcement by law, enforcement by the police. And what do the police do when they enforce criminal penalties? Well, they go and do an investigation. And so often when you're talking about investigating a potential abortion, whether you're investigating the provider and these laws differ a little bit in their scope as to whether it's the provider or the person who sought the abortion or both. Either way, you're of course dealing with this issue of protected health information, PHI, as we call it, because HIPAA calls it that. Now, there's as you said, this doesn't protect everything. There's different definitions, but it protects the core of what we would think, ought to be confidential. Most of the stuff related to treatment and care, including conversations with your doctor. And as you mentioned, when the first decision came out, a lot of people were saying, "Oh, we've got HIPAA, thank goodness."
Yeah.
HIPAA, as a federal law, preempts state laws. And therefore ought to cover and continue to provide protection so that if I seek an abortion, whether it's in my state or outside of my state, or have conversations, or I'm treated because of a failed abortion, for a miscarriage, that these things, will still be private. And so it will be difficult to enforce. Well, as it turns out, people were not paying attention. People made that offhand suggestion, not people who understand HIPAA as you do. People are experts. HIPAA expressly excludes from coverage, or provides an exception, I suppose is a better way to say it. That and take one more step back. The way HIPAA protects your information is it gives you the control. The entity that owns that stores the information is not permitted to disclose it without your permission. That's why it's so difficult to get even your own information sometimes from a doctor's office, and certainly to share it with other people. We're trying to protect your privacy, but that protection does not extend to a situation where there is a criminal investigation by law enforcement. And there's an exception where they are permitted, and this we'll get into the next stuff we'll talk about. They're permitted to provide without a patient's authorization or person's authorization information to law enforcement in a criminal investigation. And so since most of these laws are criminal laws, that exception would in essence eliminate the protections overall. So that's our first concern, right? And then you were starting to describe more in detail the kinds of information that, although they be otherwise protected, nonetheless might fall within this exception because they would be useful in investigations. And so sorry to interrupt you, but go ahead.
Oh, no, that's great, Brian. No, I guess I was just going to get to the point of saying there's a lot of information though that does fall outside of HIPAA, which gets really into your area even more as far as the use of apps and text messages and all these things that we're not even talking about having a healthcare provider involved necessarily. Maybe if the service is connected to your healthcare provider. But if it's not, if you're doing something like a fertility app, or or a period tracking app, you could just be texting, your sister or something. These are all areas, though, that we don't see that sort of same protection as far as medical information, which definitely opens up a whole can of worms. And one other thing I'm just going to say before you get into that, it's important to understand that we have seen these issues going on well before the Dobbs decision came down. So it's not that the gaps in privacy or these issues have not been going on. We know that there have been many instances where women for various reasons have been involved in some reproductive conduct that has resulted in them being charged criminally. It's just really that it's taken it to another level. It's really heightened it at this point with the Dobbs decision coming down, and this much more greater potential enforcement of criminalizing abortion at the state level.
Yeah, and so before we move on to the areas not covered by HIPAA, and we'll explain that second. As you said, like, this is not new, right? This exception for criminal enforcement has been cropped up, although in a less probably less extensive or potentially extensive way than we're starting to see with these new laws, but certainly a less prominent way for the general public, right? The news around the Dobbs decision is widely known. It's a huge issue in the midterm elections. And so one last point on HIPAA itself, though, as I was emphasizing, the exception permits, right? And so the Biden administration has been very aggressive, came out right away with a number of recommendations through the agency or guidance through the agency, Health and Human Services, or HHS. What did the guidance related to that to that particular criminal enforcement exception say, and what's its likely effect, do you think?
Yeah, I thank you, Brian. I mean, I think one important thing, and you've been definitely saying it, is that HIPAA permits, and this is something that is really emphasized in this guidance that's out. It permits them to disclose, like a medical professional, like say, Cleveland police comes to a doctor at Cleveland Clinic. It would permit them to release the information, but it would not require them to. So it is important that the administration has definitely emphasized that. And there can be other, things involved in this too. I mean, they may have a search warrant, they may have some legal document that they're a subpoena that they're trying to, obtain information in that respect. But again, the Biden administration has really emphasized that it is permissible for a medical professional to release information, but they are not required to. And then ensuring that, if we're talking about like a statute, a law like Ohio's heartbeat law, that that is specifically, it has to be written into the law that there is this restriction and what that looks like. It can't just be that the police are just like seeking anything and everything, but it has to be based in the law, and there has to be that connection.
Yeah, could you elaborate a little more on that? And so, in other words, it's not that the exception extends broadly to just the police being interested and doing a kind of broad investigation to hope to find leads, but what explain a little bit more, what is this specific legal authority?
I mean, there's different avenues. It has to be like they have to have some sort of a legal document. We're talking about a warrant, and I mean there are some different warrants that exist, and then or it can be a court order to seek such information. It may be also another potentially big area that we can think of as child abuse. That is one that we frequently see where an agency is trying to obtain information, because frequently when we have these situations, for example, if a mother is, involved in drugs, then they may be seeking information that way. But they have to have some sort of a legal, document that is they're attempting to seek this information.
Yeah, and so most commonly you'd see it as a search warrant in a criminal
Yeah.
context. It could be a subpoena. And so while there is this exception, that guidance from HHS is intended to say, well, just because the police show up and say we're investigating something, a potential abortion or something else, doesn't mean you just roll over and play dead. Now, in the face of a warrant or some other, court order, some specific mandate that's enforceable in a court, then hospitals have no choice. It's not as if they can stand on the HIPAA permission and say, well, it's up to us to decide. But at least in the first instance, they shouldn't feel like the exception requires them to just give it up just because the police show up in the course of an initial investigation. The police have to take that next step, which provides at least some temporary, potentially temporary protection, and at least excludes sort of fishing expeditions by the police where they suspect something's gone on, but they don't have enough information that would justify the probable cause standard for a warrant. So, so it's not as if HIPAA doesn't protect it all, but when push comes to shove, if the police can get a warrant or some other form of legal authority, then HIPAA's exception kicks in. So HIPAA, even for the information that it protects against disclosure, is really limited in this context. And as you started to talk about, there's also a whole other set of what we might colloquially consider health information that simply is not covered by HIPAA. And as you were saying, HIPAA, and you said this at the top, but let's reiterate it, HIPAA primarily covers what kinds of organizations?
We're talking healthcare providers, your doctor. It can cover healthcare plans, clearinghouses, but it has very limited actors. It's not an unlimited list. It's clearly defined in the law. These particular groups fall under, as defined as covered entities. So it's really, we have a very structured and a very limited group of individuals that the law says basically they are supposed to be, ensuring the protection of this protected health information, which is a big criticism. It's been a criticism of HIPAA for a long, long time. I forgot to mention websites too. That's another one. Like just your online searching could end up, if you're searching for, trying to purchase, prescriptions and also the telehealth area, right? Going through that experience may open you up. Just from your web searching, that's what I'm really pointing to, though. May end up,
and before we go there, just to underscore that point. So HIPAA does not define certain information as health information and say this is sensitive and therefore anybody who touches it has to, it certainly does not require this very specific authorization for disclosure. That all of its protections are limited to this group of entities, which primarily it's whoever provides you healthcare services, and then entities that they contract with to that need your information to do the business.
Sure, businesses, and they call that business associates, right?
Business associate, but it's got to be in the context. In other words, it's when you go see a doctor, when you go have, it's a little broader than this, but functionally you're getting healthcare services in some formalized way. And so, of course, there are a variety of other ways in which we seek to have healthcare services provided, or ourselves are trying to, do things for our health, right? And so these are often mistaken. This happened during the pandemic when we started thinking about digital contact tracing apps. A lot of people thought, oh, well, HIPAA will extend to these applications if you're collecting data that might be used to determine if you're symptomatic or been exposed to someone symptomatic. And unless those apps are created and the information is collected directly by one of these limited group of healthcare providers, covered entities, it's not, right? And so that's one of the big issues that's emerged. It's connected to the broader problems around consumer data privacy and the fact that apps that collect what is clearly sensitive information don't have very strong obligations unless they're in a state like Illinois that has protections for certain kinds of information, or California and the several other states that have started to have broad general consumer privacy laws. It's pretty limited. The FTC has some authority over these apps, but it's limited largely to enforcing the privacy policy that they put out to make sure they're doing it. Although the FTC has made some has said explicitly that it's going to start to interpret its authority maybe a little bit more broadly. But generally speaking, if you're using an app, and the apps that are most sort of came to light initially are period tracking apps, because those obviously provide data that could be incriminating in the case of an attempted abortion or a successful abortion, but also other apps that are collecting information about you, including just location, right? Why, for example, is location data independently sensitive for someone who is seeking abortion or succeeded in obtaining an abortion in a state where it's illegal? So when we think about location, right?
Yeah.
People know where abortion providers are.
Sure.
And for that matter, if you're attempting to get an abortion from an unlicensed provider, from a friend or someone, you could implicate them. And so all the concerns that are raised by data privacy in general, all of a sudden we're paying attention to the fact that, like, HIPAA just leaves them out, right? Even though they're connected to healthcare services, and as you pointed out, even just the searches you run. If you run searches, saying how to perform an abortion,
Right.
where is abortion provided?
Sure.
Those are all things that the search engine companies, Google most prominently, if they get a warrant, will have to provide to authorities.
Yeah, I think
and
some
so-
of the advice has been to delete your history, right? I mean, because
Right.
at this point right now, it's, we don't know. I mean, somebody could get a hold of your information. I mean, and think about the use of social media today, especially like Facebook, where people are pretty open about things. But even, I mean, law enforcement can certainly subpoena your Facebook records.
You're right. And so all of a sudden, this is all stuff we've been aware of, and there's been increasing concern around it. There are some laws pending at the federal level, including laws directed specifically at these issues. But as it stands now, we have what we call a siloed set of protections that leave lots of gaps. At the federal level, HIPAA protects certain narrow things that we've talked about. The FTC has some general authority around consumer privacy, but it doesn't extend very far. And then otherwise, there are state laws that cover to some extent, but almost all of these laws still have exceptions for criminal investigations,
Right.
like HIPAA itself. And so what we're now seeing is, unless you were already kind of living your life in a complicated way, or were paying attention to privacy, like I do, and trying to do things to maintain personal data hygiene, just as a general matter, you got to live your life in a pretty complicated way to actually try to take control of your own data. And of course, HHS, is part of its guidance, just recommended to individuals, underscored that we don't cover apps, we don't cover Google searches, we don't cover these kinds of things. You should, as an individual, begin to think about how you're using services, and then try to, as you said, minimize the information. But that's really hard to do. Right? So you think about location. So even if I turn location off on my phone, which is a pain, because a lot of your apps rely on it for a variety of things that you wouldn't think of, weather. You can't use Google Maps, right? Which, how many of us have an atlas in our car? But even if I do that, even if I turn off location services as a matter of my phone, we can still get that information, right? From cell tower data, right? The cell towers are constantly tracking. And so unless you actually well, what criminals do is use burner phones, right? So that you're
Right.
not maintaining a record of your device. It's really hard if you're going to live your life in, even if you go to fairly great lengths, use tools like a virtual private network and others to avoid having your searches tracked, keep your location off. You really have to really definitively protect yourself. You'd have to not use a smartphone, which.
Yeah. And I think
most of us
and what so many, I mean, obviously it depends too on what state you're in. I mean, that's a big part of this right now. How restrictive is your state? Does it allow abortion? I mean, this is something that I mean, doctors are struggling just to figure this out. So, just having that knowledge and information about what is our regulation now in this state. And I mean,
Right.
so many of the states we're in litigation right now just to including Ohio, right? To determine, what are the boundaries going to be.
Right. And that is another great point. So, you have to figure out what your state laws are and what the status of, because most of them are being challenged in one form or another. And also what laws are being, are on the ballot right now that might change the situation you're in. And then that dictates, the extent to which you might have to worry about this. But of course, the possibility that new laws could come online at some point, just makes it, increasingly, if you may potentially need to seek an abortion for some reason, you functionally need to start paying attention to what data you have and how you're living your life in a way that most people don't, unless they're subject to some investigation or harassment or something else. And that's one of the side effects of this. So the Supreme Court framed the decision as opening the door for democratic change. And it's true, it does. But we've got a society that's rested on the principle that, within a fair degree of potential limitations, but at least within a certain window, abortion was available. And now clearly we're going to have a number of states where that's not true anymore. And then you got to start paying attention to your information.
Yeah, I just wanted to add one point to what you said about location too, because we know that many people are traveling to get abortions now, and that's why that becomes particularly important. They're traveling from a state that is very restrictive as far as abortion access to one that is not, and we're hearing about that, and obviously that makes your location following very important.
Right, and raises questions about extraterritorial jurisdiction of state laws. If you're from a state that prohibits abortions, we saw that for some of the laws that were being brought before or under litigation even before Dobbs. Real questions about by their terms they seem to extend to people outside of the particular state, and so just lots and lots of uncertainty, and again uncertainty that potentially data might end up putting people into legal jeopardy. Mm-hmm. So with that, we're at 12:33. I want to open the floor for questions from our three folks who are attending live. If you've got a question, feel free to raise your hand. Within this, I think we've got that function enabled, or put it into the Q&A. And going once, going twice. Okay, so with that, I'm going to turn things back to Julie. I'm going to pull up our slide deck again. Laura, thank you very much for taking the time to talk with us today.
My pleasure.
I mean, it's great. We've colleagues like you, in our at Cleveland Marshall, doing great work on this. And although you don't teach directly in our program yet, we do have a HIPAA and privacy course that we'll talk about. And also one of the nice things about being attached to the program is you're a student of Cleveland Marshall. And so you have access to folks like Laura and all of our other professors. And
I get a lot of MLS students in my health law courses. So and I enjoy it so much.
Yeah, and we're going to walk through the curriculum right now. But as we'll emphasize, these are the courses we've created that if you want to have a fully online asynchronous experience, or largely, because we do have live classes within them, this enables you to do that. But as an MLS student, you're free if it fits your where you live and your schedule to take other courses like the ones that Laura offers. But with that, thank you, Laura.
Thank you.
You're welcome to hang on, or you're welcome to
Okay.
to drop. But we're going to now pivot over to the program. And
Bye, Julie.
actually, Julie,
Bye,
I'm
Brian.
going to
Thank you so
bye,
much, Laura.
Thank you.
Bye.
And I'm going to, oh, there we go. There we go. Actually, Julie, before you return, I'll just talk through the curriculum real quick, and then I'll let you wrap up. And again, folks, if you have questions, just raise your hand or put them in the Q&A. Oh, what did I do there? There we go. Okay, so our program goes into depth about the kinds of issues we were just talking about with Dr. Hoffman. HIPAA and privacy, as you see on this sheet, is one of the courses that we've built. All of our courses in this program are asynchronous with some, in most cases, live classes throughout, but it's structured to enable folks who are working professionals, regardless of where you live, to take the program. And so for most of the courses, you're doing them in modules where you have time within certain deadlines within a week to get the work done. And then, as I said, we have optional live classes, which we record and provide to everybody. The program is designed to give you a 360-degree view of cybersecurity and data privacy. We are a law school, so we have a heavy emphasis on the law and policy side in the upper level, but we also give you a thorough grounding on the technical side. And so we created the curriculum to serve a diverse set of needs ranging from people who are already IT professionals or even in a cybersecurity role on the technical side, and they want to go deeper because they recognize it'll advance their career to understand the law and policy and strategic dimensions, as well as for folks who are in compliance or otherwise in a legal role, and even for JDs, people who already have the Juris Doctorate, the law degree. All of our courses except the Intro to American Law and Legal Writing are relevant, and we can work with you to round it out so that you can take some other courses. But on the legal side, we start you with either Introduction to American Law or Legal Writing. These courses give you a foundation in law for folks without a law background, with an emphasis on how law comes up in a cybersecurity and data privacy context. I teach the Introduction to American Law course. It's a survey that goes through all of the major areas of law that you would encounter. It's essentially gives you a really condensed version of most of what you get in the first year of law school, as well as some of the upper level topics that are important in this area. Legal writing then goes deeper on how you do legal research, how you read, consume, and to some extent create legal documents, which is a critical skill wherever you sit in cybersecurity data privacy role. Even if you're on the technical side, you're going to be working with lawyers, and really a lot of the work you do in setting up controls and other things are driven by these laws, and you'll be, especially if you move up the ranks, be working with legal professionals, and this teaches you how to understand what they're saying and also independently evaluate to some extent what new laws are requiring. And of course, we just talked about the laws are changing quite a bit in this field. Then on the technical side, the two foundational courses are Cybersecurity 1 and 2. Cybersecurity 1, you'll do open source Kali Linux labs to understand how cyber attacks work and understand just generally how data systems operate and where their vulnerabilities are. It really kind of throws you in the deep end if you don't have a technical background, but it's designed for people who don't have a technical background. We do have people who come from IT and even security who take these courses and still find them valuable. But we work with you to really get you to understand how to do this, even if you don't have any background whatsoever. Cybersecurity 2 then expands that and connects it to law by requiring you to, it goes over some of the same topics to review, but then also you do a project where you're developing the technical controls for an entity a lot like Cleveland State University that has a range of regulatory requirements in security. And then privacy law and management is our third legal course that now gets deep into the substance. It's a survey course that goes through all of the major federal and state laws in this field, and then works through how to operationalize them through a privacy and to some extent security program. Then in the upper level, corporate compliance 1 and 2 pulls the lens back from privacy and security per se and situates them in the broader context of compliance. Compliance is a very specific field in the United States. It's a field that both lawyers and non-lawyers, professionals, including even chief privacy officers, operate within. And so understanding how privacy and data security fit in a general program and how to build one of those programs is a key piece of what you learn in our program. And then, as I mentioned, HIPAA and privacy, we just talked about HIPAA at length. It's the most complex, currently, at least federal law in this field. It has both security and privacy requirements. And so we have students do a deep dive on it because understanding HIPAA, all of the other laws, state laws are emerging in ways that are a little bit different from HIPAA, but generally speaking, the concepts around what data is sensitive and how we are going to protect it, both from a matter of security and privacy. HIPAA is really the sort of foundational law in the United States at the federal level. And then finally, we have cyber law, which goes into the national security and criminal law dimensions. It's taught by a professor at the United States Air Force Academy, a former member of Cyber Command with deep experience here. And then the technical capstone is our final course on the security side, technical security side, and you use the Ohio Cyber Range, which we're a member of, and go through some labs that are lightly mapped to the Certified Ethical Hacking certificate. And so that's our program. As I mentioned, though, as an MLS student in the program, you can take other courses offered by the law school if they fit within your schedule. We just don't structure them in a way that you can take them asynchronously with these. With this, you can go through the whole program and complete it completely online, but you've got some flexibility. And so with that, back to Julie.
Yeah, thank you so much, Brian. Thank you. And of course, if you have more questions about the curriculum, you can reach out directly to me or to Brian, and we can answer your questions more in depth. We do want to get you out of here by 12:45, so I will go over this briefly. Next steps, if you are indeed interested in applying for this program. So the good news is that we enroll students in every term, so fall, spring, and summer. So our next session begins this upcoming spring semester, which for us, it'll start on January 9th. And the application for that is due on January 4th. The application is very simple. You will go to our webpage, onlinelaw.csuohio.edu. You will need a resume, a personal statement describing why you're interested in this program or what your career goals are once you complete this program, and then your transcripts from your undergrad. And again, I'm happy to speak with you in depth about the personal statement or any other of the application requirements. We try to make it very simple and we try to work with you where you're at. So always please reach out to us. But again, our next session starts this upcoming spring semester, which starts January 9th with an application of January 4th. Brian, can you go to the next slide? Thank you. So here's our contact information. So this email, the mlsonline@law.csuohio.edu, comes directly to both Brian and I. So any questions that you have about what you learned today, of course, if you want to speak to Professor Laura Hoffman, I'm sure she'd be more than happy to answer more of your questions. You can give us a call at that, or give us an email at that email address, and Brian and I will be happy to answer your questions. You can also give me a call at the number there provided with anything. We really like to talk to you before you start the application process one, to make sure this program is a great fit, and then two, to make sure that you have a seamless application process. That's all I have. Brian, is there anything else you'd like to add before we let them go?
No, that's it. As Julie mentioned, we're happy to talk to you. Contact Julie directly, but I'm also eager to talk to prospective students. And, if you've got questions about whether your experience fits or whether there's certain things that you might not need to take, we're always happy to try to configure the program to fit your needs.
That is true.
Thanks, Julie.
Thank you. Thank you, Brian, and thank you everyone who attended today. Bye.